5 of the supplementary list. That's the conducting counsel is not present due to some personal difficulty.
On prayer of learned counsel.
And for the day, Lordship.
Item?
5.
I've already.
Yes, Your Lordship. I beg to mention item number 18, Your Lordship. Actually, yesterday filed an additional affidavit, Your Lordship. So could not take with this main brief, Your Lordship. So may allow the direction to the registry for take this.
Item
it
18, it is submitted that an additional affidavit has been filed in the case, but the same is not tagged with the record. Registry is directed to the matter again after tagging the said additional affidavit. On
Tomorrow maybe, if possible, Your Lordship, tomorrow may be fixed, Your Lordship. Because
cannot
there
be
have
possible, it's too late, I think, already.
Lordship, because there have two accused person. One is suffering illness, Your Lordship. She is in jail, Your Lordship. So tomorrow may be fixed.
Right, we'll see if it is listed well and good. Yes, next.
May I please, Your Lordship. Lordship, item number 20, I beg to mention item number 23. The conducting counsel is starting from fever.
Right. When do you want?
Applying for 1 week time. List after 1 week. Public. 23, no? 23.
May I please, Lordship? Lordship, I beg to mention item number 9, Lordship. Lordship, there are some discrepancies in filing the petition, Lordship. So I may be allowed to withdraw the petition and file
Item
afresh.
9 on prayer of learned. Mr.
N.M. Ajarbuya.
Is withdrawn with liberty to file afresh.
Obliged, Lordship.
I beg to mention item number 1, my lord. The leading counsel is for the medical difficulties. He left the court, my lord.
All right.
Matter may be come off Thursday or Friday.
Any matters already? Monday.
Plus.
Please, Your Lordship. Lordship, matter related to criminal revision petition. Learned additional session judge FTC Shonitpur give a conviction on 3 months only and paid a fine of rupees 53,000, my lord. Well, I am ready to pay the 53,000 amount, my lord, within 7 days, my lord. Right now, I am in a jail, my lord. I was arrested on 4/2/2026. My lord, 34 days is behind the bar, my lord, today.
So you are already convicted.
Yeah, I am already convicted, my lord. 3-month conviction, my lord, and pay the amount of rupees 53,000, my lord.
What's the compensation amount?
Compensation amount, my lord.
53.
53,000. And in 53,000, I am ready to pay, my lord. Now I am in the jail, my lord. I was arrested on 4/2/2026, my lord. Till today, 34 days, my lord.
This revision petition is the order dated 3/12/25 passed by the learned additional session judge FTC Sonitpur Tezpur in criminal appeal number 26 of 23 whereby the said appeal was dismissed compliance with the direction for deposition of 25% of the check amount accordance with the mandate of section 148 in bracket 1 NI Act. Petitioner was earlier convicted sentenced to undergo SI for 3 months and to pay an amount of rupees 3,000 as the tenant. In default thereof, undergo imprisonment for another 3 months. Call for the by speed post AD. Right, it's petitioner herein is ready to deposit the 1,000. It is.
Yeah.
How many days in jail?
34 days.
Hours. Para having regard to the above. Trying to say the dated. It pays 13, okay, title. Direction for bail is required.
My lord,
Or you should have contained it.
Judicial Minister First Class Sonitpur.
You have only prayed for stay.
My lord, I is there, my lord.
I is there.
I also there, yes, my lord. I number is 242. For regarding bail.
Stay. Stay until the it of subject to deposition of rupees 53,000 by the petitioner within how many days?
Within 7 days.
Within 7 days from today. Before the court,
The court magistrate.
further learned, which measure? Judicial magistrate,
Judicial
class.
magistrate first class unit.
then in IA 24. Application for bail of the petitioner, namely Ainu Soikia, who was acted on the strength of NBWA pursuant to her conviction in NI case number 43 of 2019. Whereby she was sentenced to undergo same, okay, 3 years, 3 months. In view of order passed in the 26 passed today, okay. The prayer for bail is allowed on the same condition. Said order passed today. That is deposit of 3,000 by the petitioner within a period of 7 days. Highest and disposed of according.
Published one.
Please, Lordship. Lordship, this revision petition has been filed against the judgment and order dated 4/2/2026, asked in criminal appeal by the learned session judge, whereby dismissing the appeal and upheld the judgment and order passed in NI case, whereby sentence of 2 months and fine of 3 lakhs has been upheld. My lord, impugned judgment is at page 34. And the fact of the case is that one agreement was executed between the petitioner and the respondent, and an amount of 2,50,000 has been paid by the respondent to the petitioner as alleged by them. But our contention in this case was that I have give only 1 lakh rupees, that is by oral agreement, and I have successfully exhibited exhibit A in my defense witness, by which it is proved that I have paid, returned the 1 lakh amount to the respondent. It is in the page number 41, my lord. May I read? The appellant in middle portion, my lord. The appellant accused in his evidence has exhibited his passbook maintained at SBI as Exhibit A and has proved an entry that dated 19/1/2017 as Exhibit A2, which shows that an amount of 1 lakh was transferred to the account of the respondent on 19/1/2017. But my lord, in the impugned judgment and order of NI Act, it was denied by the respondent that it was related to other payment. But when a agreement was cancelled by whatever means, so definitely 1 lakh is given to his account as a return of that amount. But my lord, in this case, accused has successfully rebutted his claim of the presumption raised in favor of the petitioner. So it is the onus shift to the complainant to disprove it otherwise. But he simply says that this is not the amount received in return of the execution of sale agreement. So in this initial stage, my lord, I have a prayer that notice may be issued. My prayer may be considered. I interrupt, my
What evidence did you lead? Nothing.
my lord.
What evidence did you lead to rebut the presumption? Nothing.
My lord, in the impugned judgment and order of trial court at page 14, it was, my lord, at page,
In course of his evidence, as DW1 remains silent about execution of
my lord, in the,
Exhibit 1 and his signatures appearing thereon.
my lord, that
And
is,
he acknowledged the receipt of advanced amount on different dates.
my lord, that is,
He asserted having filed a police complaint but did not exhibit the azahar.
that is appellate
Failed
court
to
decision,
lead
my
any
lord.
evidence that his
My lord,
signature appearing in Exhibit 1 not his.
at page 23 of trial court judgment.
We are on the appellate court judgment now. What is wrong in that judgment?
Because these facts are there in the trial court judgment which are not appreciated by the honorable
What is
appellate
not
court.
appreciated?
This,
Is this finding wrong?
I am challenging that because Exhibit A is the photocopy of bank passbook, SBI Shivsa government. It was in the page 23 of trial court judgment, which are not appreciated properly in the appellate stage. And Exhibit A2 is the entry dated so-and-so transfer of payment of 1 lakh to the account of the complainant Nityananda Das. And in the next page 24, he denied that Exhibit 1.1 and Exhibit 1.2 are his signatures because there is 3 payment dates. First payment is he admitted and he has returned that amount, but other 2 signatures are not his signatures. And in page 28, it is pertinent to state that the defense have exhibited the passbook Exhibit A and the entry dated so-and-so of transfer payment 1 lakh to the account of the complainant Nityananda Das Exhibit A2. The said receipt of 1 lakh is not disputed by the complainant. That very complainant in trials are not disputed. These are facts not appreciated in the appellate stage. But he claims that it relates to separate transaction. So he has not disputed that he has received 1 lakh rupees, but it is related to separate transaction. But he has not said.
In order to rebut the presumption, you have to prove that it was paid in connection with the same transaction.
I have so exhibited the passbook that I have paid that amount. But here, complainant also not denied. But he said it is not related to the separate transaction. So, onus of disproving the rebuttal is shift to the complainant, which are not appreciated in the appellate stage. And age of the petitioner, my lord, is 77 years old. He has said that the transaction between him and the accused are not related to the check in question. But when agreement was cancelled, thereafter 1 lakh is repaid. So it definitely relates to that amount. He has said that I have returned back that amount. But complainant simply denied that it was not related to the check in question. But he has not said for what transaction he has received that 1 lakh rupees. After failure of the land agreement, 1 lakh was returned in his account, and complainant has not denied that, he accepted it, simply said that it is not related to check in question. But the onus of disproving the rebuttal shift to the complainant. These are the facts I have.
But the check amount is 2,50,000.
That
If you took 1
agree-
lakh, why would you pay? Why would you give a check for 2,50,000?
that is lordship has if discussed in the judgment, it is that he has not given any police report. So that is true, but I will
No,
satisfy.
it's not about police report. Question is,
He has said that
if you
I have not
took 1 lakh, why did you give a check for 2,50,000?
that was security check. It was not written by him. He
Even if
said
it is
that,
security check, it is attracted.
but his signatures are, he denied.
At this stage, notice may be issued and interim order may be at the time of after service of notice.
Already heard learned counsel for the petitioner. This is an is directed against the so and so. To notice to the speed post. Is the matter again on.
My lord, I have a humble prayer. I may be considered because he has to be surrendered last on 6th. We have filed a petition to have some time, and his age is 77. So it may be considered whatever may be come out from this case.
IA 243. 8. Application for allowing the petitioner to remain on previous bail in connection with case number 06 of 22, wherein the petitioner was convicted and to undergo SI for 2 months and to pay a fine of rupees 3 lakhs, which was upheld by the learned session Judge Sagar in criminal appeal number within bracket 3 of 2025. It is submitted that 77-year-old the considering the facts of the case, he may be allowed to remain on previous bail. Having regard to the government's made prayer for previous bail is allowed, the petitioner so and so remain on previous bail. Be passed in the connected criminal revision petition. The IA stands disposed of accordingly.
Highly blessed.
Please, your lordship.
is a revision petition, my lord, the classic case of jurisdictional error. In this case, what had happened, my lord? Petitioners before your lordship, they were discharged by the learned trial court, by the learned magistrates court. Now, your lordship knows once there is an order of discharge, if the state or the victim wants to assail that, they have to file a revision. There is a revisable order, my lord. Here, after 9 months of discharge, the victim goes and files an appeal before the Court of Sessions, and the Court of Sessions admits the appeal, sets aside the discharge order in that appeal manner. Here, your lordship will first kindly see the discharge order at page 34. Petitioners, the accusations against the petitioners were under section 408 and 420, read with 34. Relevant portion your lordship will find at page 37, second last paragraph. The accused persons, so-and-so, so-and-so, so-and-so are discharged from section so-and-so, invoking power under section 239 of the CRPC. Now, this order was passed on 5/11/2024. Now, your lordship will kindly come to page 38. The victim files this appeal under section 413, 2023, the proviso 413 or the victim's right of appeal. Now, your lordship knows 413, the right of appeal is only against an order of acquittal or an order of inadequate sentence or inadequacy of compensation. In that regard, the victim can file. Victim has been given a statutory right of appeal. Beyond that, an appeal will only lie when it is sanctioned by the statute. Now, BNSS does not sanction an appeal against an order of discharge. Irrespective of this, this appeal gets filed, and your lordship will see this appeal was filed on 31/7/2025. So that is almost 9 months after the incident. No section 5 application is there for delaying the condonation. However, at page 44, the affidavit which is there connected to the appeal, your lordship has page 44, Everman 7, 6 and 7. So in the affidavit, they have made it that there is a delay of 231 days, which is not intentional, which may be condoned. Now, your lordship will kindly come to page 46. On page 40, this is the first date the matter is taken up, it is adjourned. Next date, page 47, on 18/8, without condonation of the delay, appeal is admitted for hearing. Eventually, at page 48, my lord, I have given the judgment also at 49, the appeal is allowed and the discharge order is set aside. So, first of all, appeal itself was not maintainable. Revision ought to have been filed. Secondly, the appeal, even if you assume that appeal was maintainable, this
Was
was
there any discussion on the point of maintainability?
no, my lord. Though this point was, we had raised this point, but no discussion in the judgment, my lord. So now matter has been remanded back and the trial against us has resumed. Delay part is also, the delay has also not been condoned. And appeal in itself is not maintainable, so delay occasion will also not arise. But even if you assume that part, even then it is barred by limitation. So perversity might not take large on
Mr. Learned Counsel. Learned additional. This revision is directed against the judgment order dated 21/11/2025, passed by the learned additional session judge Dibrugarh in criminal appeal number 31 within bracket 2025, whereby an order of discharge passed by the learned. Who passed the order of discharge?
Judicial Magistrate First Class Dibrugarh,
Dated
5/11/2024.
has been set aside, where it is submitted that as against an order of discharge, no appeal lies under section
413
413
of the BNSS.
413 BNSS. And there is no other provision permitting such an appeal. And the order impugned therein is a revisable order. Moreover, the said appeal was preferred after a delay of about 9 months. There is no order condoning the said delay. The learned court stated in the appeal notice to the respondents steps by speed post AD. Having regard to the submit above the impugned so and so same appellate order, okay, 21/11/25 passed in so and so hereby stayed and further proceedings in
PRC case number 111 of 2024.
pending before the
Learned Judicial Magistrate, First Class, Dibrugarh.
so remain stayed till until further orders. We know.
From deep level.
Yeah, Mr. Lordship. Lordship, this is a matter on quashing of an FIR. Why to keep book of police case number 91 oblique unit in the The application is Lordship, the FIR is in page number 10. The allegation is that on date 31st/07/2025 at around 1:30 p.m. the higher authority came to know from a reliable source that a racket who involves in transportation of fake currency, loans, black money from businessmen is coming towards Tukipuko from Gauhati, and further the SSP provide the live location of the mobile numbers and instructed to follow the live location. As per the direction, the complainant conducted the Nanga checking near Narayan Situ. During Nanga checking at around 2:20 p.m., one vehicle bearing number IS01FY 4447 was proceeding from Kolabara towards Tugipokon side. Then on seeking the Nanga checking, the team immediately turned back the vehicle towards Kolabara. Then the complainant, along with his staff, chased the vehicle and with the help of the Kolabara police apprehended the below noted for accused person along with the vehicle. On interrogation, the apprehended persons could not give proper answer on their identity and their whereabouts.
Matlab, they are carrying fake identity card. Matlab, one of the person's identity card shown as National Intelligence Bureau, NIB member. One is National Crime Research Intelligence Bureau. These are matlab, they are carrying. Where is the harm? Matlab, the investigation may go on. Matlab, then if they are not at all involved, matlab, they will be matlab, research, and if there is any materials, they will be suspected, matlab. So matlab, prima facie, matlab, they are carrying fake identity. It's apparent from the FIR itself, matlab. But these are not cases for matlab, washing the matlab, FIR. Let the investigation be go on, matlab. They are trying to loot matlab, crores of rupees in the way matlab, police got secret information and caught the Naka checking with fake identity card.
My lord, the petitioner is a holder of Assam Rifle. And while the petitioner was posted as Assam Rifle transit came Gauhati, and a fire was lodged against the petitioner.
Okay, we'll examine. Heard learned counsel for the petition and also heard learned additional PP. This is an application seeking quashing of an FIR connection with Zogigo Papias case number 91 of 2025 under section 61 2 stroke 3010-4 3192 of BNS. Copy has been served.
My lord, we have, my lord.
We need the CD.
Yes,
That investigation stage only, isn't it?
investigation.
Call for the CD of the
Yes, 9.
aforesaid case. Place the matter again for admission on.
But this matter may be taken up after 2 weeks, my lord. We'll file an additional affidavit. Some documents were not annexed at the time of filing.
On the prayer of learned counsel for the petitioner, list the matter again on
25th, my lord.
Please, your lordship. Lord, finding no other alternative, I have before your lordship. The issue is that, my lord, I lost an affair because I deal with paddy, rice, and other deals, my lord. To get something in cheap, my lord, with the accused, my lord, they have taken a bankrupt in the name of FCI from me, and they have fraud that bankrupt and they have encashed in their name. I lost an affair. The affair is at page 18. It starts at page 18, my lord. The relevant portion is at page 22. Starts at page 22, relevant is page 24. So I was frauded by those persons, and my lord, my bank account was seized. And thereafter, my lord, I filed an Jimma. And the first order that comes upon that at page 31. My name is Abu Ahmed Mujumdar, page 31. That was in 23/12/2024. The bank guarantee, there was a direction to my lord, equal amount that was seized, the money was which was seized, that to be released. Then, my lord, at page 32, your lordship will find. Page 32, my lord. Now, my lord, I take your lordship directly to page 58. It's still pending, my lord, nothing released, page 58. Next date is given in 13/3. The date is given on 13/3 again. Since the date of the first order, that is in 2024, till it is 2026. Virtually 2 years, my money is lying. I cannot get it after a direction from the court also. I can file a contempt against that order. I have to come to High Court again, madam. So if your lordship can dispose of with a direction to complete it within the next date fixed, the trial court, madam. Every time the banks comes and other comes and takes time, and it is continuing for last 2 years after a direction from the session court and the trial court.
But what is my scope for interference?
Only for a direction, that much, that, my lord. I'm not asking for any kind of setting aside. I'm asking for a direction, my lord, that they to complete the issue, because there is already a direction.
That is what I'm saying.
Dispose of the matter as expeditiously as soon as possible, my lord. Because your
It is
lordship
not a challenge to any order.
But I have not challenged any order. I have not challenged any order. For ends of justice, I am coming before your lordship, madam. Because 2 years after the learned trial court and the session court has passed an order, my money still has not been given to me by the banks. To expedite the issue and complete it within a reasonable period. That much is my prayer, madam. Since fixing from 13 to 26, again 13/3/26 has come. Another 1 month has gone. And money is not a little money, but around 10 lakhs of rupees, man.
What is the amount, total amount?
My lord, in the affair, it has been given around 10 lakhs.
24366,284.
My lord. Around, my lord, in page 23 in the affair, I find, my lord, some huge amounts are there. Whatever the amount is there, my lord, the IU will decide, my lord. But only thing is this, my lord, if in page 8, after page, annexure 8, page 59, I've given the amounts, my lord, there. 20. Around 2 crores, I think, my lord, I find. 1,800,000 in the last day. 2 crores 43 lakhs.
Yes, additional PP, any submission?
My lord.
Only expedite.
To expedite and dispose of the matter, my lord, because 2 years, huge amount, I'm a businessman.
Hard, Mr. PK, Chaudhary learned counsel petitioner. So hard learned additional PP. The only grievance of the present petitioner is that despite orders having been passed by the learned courts below for release of the seized money of the petitioner in Zimma, which is lying with different banks. Some of the banks have not complied with the said order, and in this regard, the proceedings are continuing before the magistrate for the last nearly 2 years. And accordingly, the petitioner seeks a direction for expeditious disposal of the matter, as he is suffering financial loss due to non-release of his money which amounts to more than 2 crores. Having regard to the aforesaid submissions and limited prayer, this criminal petition is disposed of with a direction that the learned court below where the matter is pending shall make an endeavor to dispose of the proceedings as early as possible, preferably within a period of 2 months from today. The criminal petition stands disposed of accordingly.
Obliged.
Appellate Lordship. Lordship, criminal petition for seeking bima of the vehicle Lordship. Imprint order dated 18/2/26 at page 21 Lord.
Page 21, there is a report from the IO. As per the report, the vehicle is exclusively used for illegal transportation of contraband. That is there, now. First is not there. Still in investigation stage, During investigation. During investigation, is difficult, for NDPS case,
What is this order? Jimma has been granted. Scorpio vehicle?
Lordship, it's a track,
Yes.
track Lordship.
You are praying for truck.
Track.
Achha.
And in page 21, second paragraph, 3 lines. The petitioner also claimed that the ownership of the truck, but he has not appeared before the PS and produced valid documents. So without valid documents and all this, how can bima can be given? And DPS related matters, it is difficult. Maybe confiscation also,
I've already submitted, but
But it was rejected because ownership could not be
Yes, that is, yes.
ascertained.
Seems, and there is no provision. At this stage,
Report.
report will be called from if
Third learned counsel for the petitioner and learned additional PP. This is an application challenging an order dated 18/2/26 passed by the learned additional CJM Kamrup Amingaon in the case number. Rejecting the prayer for Jimma of the truck of the petitioner. Full stop. Call for a report from the IO. List the matter again on
17th Lordship.
Wait, please, Your Lordship. This is a criminal petition for quashing of a criminal PRC case, my lord. The issue here is, my lord, regarding section 303 of the BNS, my lord, which is theft. Lordship knows that the essential requirement of theft is that property has to be dishonestly taken from the possession of a person without the consent of that person. So the most essential requirement is the presence of the owner of a property. And your Lordship will find the FIR in this case at page 12. This FIR was lodged by the police, where the police, acting on a secret information, goes and raids the house of one of the petitioners, my lord, and these three petitioners are found. And in the house, adjacent to that house, rupees 17 lakhs 59,000 rupees is found in a bag. It is the projected case of the prosecution that this money was thrown there by these petitioners. Now, this money, which the police has subsequently seized, the police claim that this money could be the proceeds of gold smuggling. So, on that premise, the investigation is initiated. Now, unaccounted money is recovered. As far as the investigation is concerned, my lord, that can be initiated acting on the premise that this might be stolen property. Now, investigation gets over. After completion of investigation, till date, there is nobody who has come forward and said that my 17 lakhs 59,000 rupees has been stolen. So the first requirement of theft, the presence of the owner is still not there. And the petitioner number 2 here, he files a Zimma petition before the court claiming that this is my money. So he says that this is my money. Of course, the money, he's still not been able to give proper account of the money. And in this regard, already the income tax department initiates a proceeding. The income tax department also comes to the magistrate's court, CJM's court, and seeks a custody of the money. But the CJM says that money has already been deposited in the treasury. So at this stage, we cannot give you the money. So for the unaccounted cash, a parallel proceeding has been initiated by the income tax department. Now, as regards these petitioners, to bring them under the ambit of theft, unless and until somebody comes and says that my money has been stolen, a prosecution.
Right, since charge sheet has been submitted.
Well, charge sheet has been submitted. Now, charge sheet has still been submitted on suspicion. FIR could have been initiated on the basis of the suspicion. But a fishing expedition cannot be conducted in the form of a trial.
Let us call for the records then. Third learned counsel for petitioner. Then application taking quashing of the criminal proceedings in PLC case number so and so, first cause title. Call for the scanned copy of the TCR. Place the matter again on. Sorry.
I'm deeply obliged, madam.
May I please, Your Lordship? Herein, Your Lordship, the respondent number 2, he lodged a written Azhar, Your Lordship, and that Azhar was registered under section 376. And in connection with this case, Your Lordship, the IO of the case made a petition before the competent court seeking liberty to file charge sheet against the petitioner, showing him as absconder, Your Lordship. And in connection with this petition, initially bailable warrant was issued and subsequently the petitioner failed to appear therein. Non-bailable warrant was issued and thereafter PNA has been issued, Your Lordship. Now the petitioner, he was not aware about pendency of this case, Your Lordship, because he stayed in Bangalore, Your Lordship, and therefore the police also never made any communication to interrogate the petitioner, and therefore he was unaware about pendency of this case as well as issuing of the NBWA and all others affecting orders, Your Lordship. Now the petitioner, he is ready to appear, Your Lordship, but due to having this order, Your Lordship, he failed to appear, Your Lordship. Annexer 2.3, initially bailable warrant there was, and the petitioner failed to appear, thereafter warrant of arrest. And subsequently proclamation and attachment has been issued, Your Lordship.
was in Hyderabad. Otherwise, rightly, directly, NBW not issued first bailable warrant, then NBW process already followed. But now I feel
Now, Your Lordship, he is ready to cooperate with the investigation, Your Lordship.
What is the cooperation to be made now after charge sheet has been filed?
No, charge sheet has not yet been filed, Your Lordship. For filing charge sheet, Your Lordship, the IO filed petition seeking liberty that to file a charge sheet, Your Lordship, absconder charge sheet against the present petitioner, Your Lordship.
All we can say is that you can appear and apply for bail.
yes.
That is all.
But since this order has been issued, Your Lordship, if he will appear, then of course.
Otherwise, you should have filed anticipatory bail application. You would have
Anticipatory bail-
considered on merit,
Anticipatory bail has already been filed here.
rejected.
And today it was moved to Your Lordship. On 24, it has,
Hmm?
the next date has been fixed on 24, Your Lordship.
Then what is the use of
Anticipatory
this?
In that case, Your Lordship, CD has been called.
Then
Then wait,
where have you
But
stated
hearing-
all this? You are filing multiple, where have you stated that you have filed separate application for anticipatory bail?
That is only.
There
for
may be
bail, Your
conflicting
Lordship, but
orders.
herein, I am for quashing the NBWA as well as PNE, Your Lordship. Hearing.
What is with the result of both? Suppose I reject this and that is allowed, what is the consequence?
But in that case, Your Lordship, the bail will grant. What I understood, Your Lordship, because in the bail petition, the warrant cannot be quashed, Your Lordship. Because the scope of
You should have filed both together. There is a risk of conflicting orders being passed in two cases. And you have suppressed that fact here also.
because that proceeding is different proceeding, Your Lordship, therefore only I have not.
same person.
But I am fairly
What
submitting,
is
Your
the
Lordship,
different
that today
proceeding?
that
You are fairly submitting after the query from the court. It is submitted on behalf of the petitioner that an anticipatory bail application on behalf of the present petitioner has already been filed. Hence, I see no reason to entertain the present criminal petition. Dismissed.
Lordship, I'm
Yes,
only
next case.
Can it be taken along with that AV, Your Lordship?
No.
All right.
None appears list after in the next week.
Worship, in this case, my lord, the petitioner number 1 is the husband, 2 is the wife, and 3 is the father of petitioner number 2 and father-in-law of petitioner number 1. But a FIR has been filed page 25 by one Noor Amin Sarkar. He is a third party, my lord, regarding child marriage, my lord, the FIR has been filed by on GP secretary, my lord. In pursuance of this FIR, my lord, the petitioner number 3 was also arrested and subsequently released. Then charge sheet has been filed, page 28. Section 9, 11, and 6. Then, my lord, Honorable Special Judge, my lord, by page 33, by order dated 5/7/2025, page 33, relevant person, my lord, page 34,
After going through the records and hearing the parties, my lord, found that offense, the petitioner number 1 committed offense under section 9 of PCM Act, and 3 has committed under section 11 of PCM Act. So POCSO is not there. And the matter has been remanded back to the Chief Judicial Magistrate to register a new PRC case, register by PRC case number 262. So my lord, here petitioners, my lord, they are doing quashing of the proceeding. So in this case, my lord, already all of the child marriage cases have already been quashed by this honorable court. I am also submitting one of before my lord.
Is not there.
Why after remand, then why is the POCSO sections appearing?
Remanding, my lord, POCSO 6 is not there, my lord. My lord, page 34. Again, my lord, section 9 and 11 of the PCM Act are triable by magistrate of first class, and hence present case is remanded back to learned Chief Judicial Magistrate so and so, who will proceed with the trial of the case after framing search on the above section of law, and will also register a new PRC case. In view of the above special case is disposed of. Ultimately,
And it says, my lord, direct notice be issued, my lord.
ultimately, my lord, there is a child also, my lord, they have a child. Ultimately, my lord, the victim is also not supporting the case of there will be,
You have made a party.
I have made a party.
The Head Learned Council for the.
Not a joint petition. It's
Joint
not a
petition.
joint.
It's not a joint petition.
Joint petition.
Also, yeah.
My lord, the victim, victim husband, they are jointly filed. They are filed.
But informant is the party is.
They have jointly filed.
Who is the informant?
Informant, my lord, they don't know, my lord, even who is he. He is an unknown person, my lord.
Your name is?
Here, my lord, 3 persons. My name is, my lord, Sajon Ali. If he is the husband of petitioner number 2, Hussein,
Alleged victim.
alleged victim. Victim is petitioner number 2. And 3 is the father of him.
So we dispose of.
23, my lord, she is now 23 as well, and FIR in 23. So 3 years also around 20.
Even POCSO is also omitted.
We will dispose of this. Number 2.
I am duty.
May please, your lordship. My lord, here in this case, my lord, the petitioner has challenged the charge sheet in the case, my lord, showing the petitioner and absconder, my lord. The affair, this charge sheet is arising out of the affair, lordship will find at page 12, 3 persons. One, Anarul Islam, Sabina Khatun, Alfaz. Alfaz is my name, my lord, although it is my nickname. As per the affair, my lord, the accused number 1 and 2 are the neighbors of the victim informant, and accused number 2 called to her house, and she took photo of the accused number of the victim along with the accused number 3. So, my lord, prima facie, no allegation. Prime accusation is against the accused number 2, not me, my lord. My lord, the accused number 2, he has also file an FIR, anticipatory bail application before this honorable court. And in that case, my lord, lordship, this honorable court has recorded finding. Lordship will find the order at page 31. Paragraph 4 says that the birth certificate of the victim, alleged victim informant, is a false one. And paragraph 6 goes to show that she is a married lady. So, my lord, finally, no case. It's absolutely Malavadi case, my lord.
So basically, court had ordered further investigation.
My lord, in the bail petition, this honorable court has ordered for further investigation regarding the status of the victim. So, my lord, my prayer at this stage, my lord, that see this section put, my lord, is a hard section. On my appearance, I may be detained. Therefore, my lord, I have challenged the, my lord, charge sheet showing me absconder, and my prayer may be, my lord, I will appear. I may contest, but
Oh, you have come here challenging the
quashing, charge sheet, my lord. False, my lord, absconder charge sheet.
for the records. You are not come here with an anticipatory bail application.
My lord, I may be allowed to some protection, interim
How
protection.
can I give? No.
My lord, if my lord, I am, my lord, arrested, my lord, some interim protection may be given, my lord. I may be allowed to appear before the trial court. Lordship may call for the scan copy of the records.
Club a bail application with an petition.
Well,
Just we can call for the
Scan copy of the DCI.
here. You have other remedies for that. Learned counsel for the petitioner. Preferred challenge seeking quashing of the postnatal asylum. There's private respondent.
my lord, private respondent, because this
Issue
section,
notice
my lord, POCSO is there, my lord.
is to the respondent number 2 steps by raised speed post with AD. Meantime, call for the scan copy of the again on.
My lord, the next date is on 12th before the trial court, my lord. I may appear, my lord. My appearance may be allowed continue, my lord, and I will appear, and I may be in the event of my appearance, my lord, I may be allowed to go on bail by the trial court, my lord.
The meantime, submitted that the next date fixed on.
On 12th, 3, my lord. Day after tomorrow, my lord.
Day after tomorrow.
Accordingly, it is provided that the petitioner may appear before the learned trial court on that day and submit application for bail. And in the event of such application being filed, the same shall be considered in accordance with law by the learned trial court.
My lord, unless, my lord, lordship pass order giving us to appear on with bail bond, my lord, that may not be helpful for us, my lord.
That is not helpful for you, then you have other remedies. Application for anticipatory bail.
My lord, then my lord, that part may not be,
Already cut it.
that part may not be, my lord. And my lord, since the charge sheet has been submitted, my lord, anticipatory bail application normally we do not prepare, my lord, but this Honorable Court has passed order in a anticipatory bail application after submitting the charge sheet. My lord, in a
You do
similar,
not want to prefer, what can we do for you?
my lord, in a similar situation, my lord, case, my lord, this Honorable Court has passed order, call for the scan copy and the petition was directed to appear, and to allow him to go on bail bond of rupees 25,000. Bail bond has been given fixed, my lord. That is an order, my lord, in a bail application, in the bail criminal petition number 160/2026. The order is, my lord, on 9/2/2026, my lord.
Don't know under what circumstances it has
My
been
lord.
passed.
My lord,
28 it is more.
my lord, since TCR has been called, my lord, the trial court record will be there. I may appear, I may be allowed to go on bail with a bail bond of
Yes, next case. Come on.
Your Lordship. Basically, this petition under section 528 of BNS, my lord, for quashing of FIR as well as the criminal proceedings. The sections are just serious, but prima facie FIR, if we go to the FIR, no ingredients are reflected. I'm directly coming to the FIR, my lord, page 23, vernacular FIR, my lord. On vernacular, my lord, I'm reading on 9th line, my lord. নজনৰ আঠমংগলৰ পিছত মোক ধবধৰাৰ থকা তেওঁ ভাড়াঘৰলৈ লৈ যায়। তাত তেওঁ আৰু তেওঁৰ মাতৃ শ্ৰীমতী জবা দত্ত হালৈ মোক মানসিক আৰু শাৰীৰিক অসত্য নিৰ্যাতন চলাই পিছদিনা পুৱতি নিশাই মোক কাৰিগাঁৱত থকা দেৱাশীষ হালৈ ডাঙৰ ককায়েকৰ ঘৰলৈ আনি তাত 2 ৰাতি ৰাখি বিভিন্ন ধৰণে মোক অত্যাচাৰ কৰে। 12 জুন তাৰিখে মোক চল চাতুৰীৰে আমিনগাঁৱৰ পিতৃগৃহৰ মোক লৈ যায়। তাৰ পিছৰ পৰা মোক লৈ যাব বুলি মিছা প্ৰলোভন দি আছে আৰু মোক মা দেউতা আৰু মই তেওঁক যোগাযোগ কৰিব চেষ্টা কৰি আছো যদিও
Already call for the
সহায় দিয়া নাই।
learned counsel for the petitioner and learned additional PP. This application has been preferred seeking quashing of the proceedings initiated by page number 2 second. Is to the respondent number 2 steps by speed post with AD within 3 days. Time call for the scan copy of the TCR. The matter again. No?
But on humble submission, Millard, the petition number 2 is Millard 66 years old lady Millard and suffering from rheumatoid arthritis Millard. And till then Millard stay may be granted Millard. Otherwise Millard, this is a totally abuse of process Millard. Because 498, she never shared any household.
You can't do it before appearance of the respondent number 2.
Lord,
Let it come. You have not come with separate application for pre-arrest bail.
till then Millard, otherwise Millard, she could not move even Millard.
Should apply for bail, pre-arrest bail.
Someone has been issued, but not yet received Millard. Some. Kindly consider Millard that aspect Millard. All allegations against the petition number 2 Millard, without sharing any single household for 1 day Millard. Is a blatant misuse of Millard 498 Millard.
That is what you should have submitted before we pass the orders. After we pass orders, you keep submitting.
I am submitting
again.
Millard. By that time, you are not Millard passing this order Millard. I am just yet to complete my submission Millard. Kindly consider the aspect Millard. Because this incident Millard, this marriage is not consumed till Millard, till date Millard. Because they tried to file the even nullity of their marriage certificate. There is legal communication is done between informant and the petition number 1.
What will happen now? Search sheet has already been filed.
Yes, Millard.
What will happen to you now within the returnable date?
Will not be arrested.
But unless consider Millard, otherwise the lady Millard, he will suffer Millard.
How will she suffer?
Lady Millard.
The court going to go to her place and drag her?
After getting summons, she has to appear before the court Millard. That's why Millard. Not paying only for petition number 2 Millard. Only consider the respect Millard. Only petition number 2 Millard.
See on the next date.
Hearing item number 17.
Problem.
Lordship, in this case, the engaged counsel has some personal difficulty today. I'm praying that the matter be listed some other time this week, Your Lordship.
Malat, I have gone through the LCR, TCA Malat. Here, Malat, charges will frame on 8/1/26. So subsequent to that, Malat, it is not there. So if we Malat fix another date, Malat, so Malat, present status after 8/1/26 can be called for Malat. If any Malat evidence Malat, that Malat we don't know. Malat.
Recorded. Right. Our learned counsel for means that copy of is up to the stage of filing of charge sheet.
No, up to the charges will frame on 8/1/26.
And it appears that charges were framed on 8/1/26, and subsequent to that, there is record available for the updated PCR. Also a status report with regard to further proceeding after the framing of charge. Again on
Can it be 20th, Your Lord? 20. 20. 23. Deeply obliged.
The appellant has been convicted for commission of offense under section 22B, and in filing connected appeal, only 2 days have been delay occurred. So in this regard, I have filed an IA before this honorable group, which is today. Kindly lordship may condone only to the
Today's delay, I have no objection. Statutory appeal, Malat.
IA 209 of 26. There has been, this is an application under section 5 of the Limitation Act seeking condonation of delay of 2 days in hearing the connected criminal appeal arising out of judgment and order of conviction and sentence dated 9/12/25 passed by learned special judge Nalbari in NDPS case number 08 of 2019. Learned PP, additional PP has no to the therefore condonation of delay. Para having regard to the reasons shown in the instant applications.
Para 5.
The therefore condonation of delay is allowed. Petition stands disposed of accordingly. Registry is registered connected appeal.
Published.
May it please your lordship. This is a legal aid matter, and in filing the connected appeal, there occurs a delay of 66 days.
What is this POCSO?
76.
The affair was first registered under the POCSO Act, then the conviction.
Counsel for the petitioner, learned additional PP.
376.
Petition under section 5, same. Is to the respondent number 2. Steps by speed post to it. AD
Now,
How will you take this? Huh?
now PROCEED is not there. Now PROCEED is not.
No, but Caesar has been made a respondent.
Oh,
So
yes, yes, yes.
we have to hear.
Yes, ma'am.
Please take in on.
Problems.
5 days. Last thought was still 2 days delay. Order. Which item was that? Which? 19. Same order.
That is a lot. Appeal against conviction, my lord, 22B NDPS Act, there is 144 days delay, my lord. I have explained my delay at para 5 and 6, my lord. 144.
Yes, PP.
Just appeal, no objection.
Heard. The petitioner and learned additional PP application. The section 5 of the Limitation Act for condonation of delay of 144 days in filing the criminal appeal. So it is stated that paragraph P
Five and six.
stated that the petitioner had approached the local council for preferring an appeal, but he was subsequently informed that the appeal would lie to the High Court. Being a driver by profession, he faced significant hardship in arranging finances for preferring the appeal, which was further hampered by the fact that he was subsequently arrested and remains in judicial custody. PP has no objection to the prayer for condonation of delay since present appeal is a statutory one. In regard to the reasons shown, I am satisfied that the petitioner was prevented by sufficient cause from approaching the court within the period of limitation. Accordingly, the delay stands I stands disposed of. Directed to register the connected appeal.
Deeply obliged.
This is a revision petition, Lordship. Lordship, here, White impugn judgment and order dated 2/2/2026. The learned additional session of business Sirang Lordship, whereby upheld and modified the conviction. So here conviction was modified 2 years from 1 year, Lordship. Actually, he was convicted by JMFC first class Disney for 2 years, and subsequently it was modified to 1 year.
You think you will modify it to 6 months? What is the allegation?
Lordship, allegation, Lordship, there is a Lordship assault, Lordship, physical assault, Lordship.
325.
But there is no single eyewitness.
Revision notice will go.
The IA is for what?
Lordship, suspension, he's there on previous bail, Lordship. So they may be allowed to remain on previous bail.
IA 244. Revision petition 114. Learned counsel for the petitioner and additional LPP. This is an application. Section 430 BNSS for suspension of sentence for allowing the petitioner to remain on previous bail. The petitioner was initially convicted by the learned SDJM M. Disney. Section 341 IPC. As well as section 325 IPC. Tends to undergo RI for 2 years. Well as fine. Subsequently, on appeal, the sentence was reduced to 1 year. So, having regard to the above, the execution of the impugned judgment and sentence hereby suspended until further order. I stands allowed and disposed of accordingly. List the appeal again on.
Revision notice should go. There is a private party, notice should go.
In a revision.
Revision. I will take steps. Normally it should be after 4 weeks. Date need not be, because notice should be served.
The appeal
After 4 weeks. Date need not be fixed because a revision. Obviously.
That to fix করে দিব that to সবতে all cases we fix dates.
Highly obvious. হ্যাঁ ঠিকই আছে নরমালি এগুলা রিভিশন না আফটার 2 ইয়ার্স সিরিয়াস পিস অফ হিয়ারিং হয় এই কারণে